Today, our group one is going to present to you chapter 6, which deals with school personnel and school district liability. You will be learning with Brandon Callahan, Quinn Connor, myself, Jenny Engel, Jonah Hang, and Jesse Walsh. As we look at school personnel and liability, we as educators need to really know and take great care that as teachers and leaders in our school, we are set to a higher standard of care than just your lay person on the street. Our teacher and administrator, as we're under the duty to possess more than the ordinary amount of care or intelligence in relation to students and their well-being. One of the reasons this connects to in our reading is that in loco parentis, where we're acting in place of the parents in order to bring care and to ensure to our greatest extent that our children are safe. Our schools are considered and presumed to be safe places where our teachers can teach and our students can learn. The prevailing view held by the courts is that we should have prudent professional educators acting in place of parents and supervising students under their care and ensuring, again, to our greatest extent, that our students are safe.
So moving on here, we'll talk about the liability of school personnel. So school personnel, they are responsible for their own tortious acts in the school environment. Liability involving school personnel normally falls into two categories: intentional torts and unintentional torts. So when we're talking about these, we're talking about what torts are, and many might not understand exactly what that is. So a tort is an act or omission that gives rise to injury or harm to another and amounts to a civil wrong for which courts impose liability. So that is why we fall into the two categories there. The intentional torts such as assault, battery, libel, slander, defamation, false arrest, malicious prosecution, and invasion of privacy require proof of intent or willfulness, whereas simple negligence as an unintentional tort does not require such proof of intent or willfulness.
Vicarious liability. So since school districts are deemed employers of teachers, they can also be held liable for the negligent behavior of their employees. A school board can be held liable for the tortious act of a teacher in the district. Under the old theory of respondent superior, the master is only responsible for authorized acts of its servants or agents. But now, generally, schools can be held liable for all acts of their employees. So vicarious liability basically just means that a school district or the board can be held liable for the tortious acts of one of their employees. And foreseeability. Foreseeability is another issue. Basically, it's a crucial element in liability, especially in cases involving negligence. Foreseeability is defined as the teacher's or administrator's ability to predict or anticipate that a certain activity or situation may prove harmful to students. For instance, the book uses the example of a broken pane of glass. If an administrator or teacher does not make an effort to warn the students of the danger of the broken pane of glass, then they could be considered to be liable for not providing some form of warning. Once this determination is made, there's an expectation that prudent steps be taken to prevent harm to students. For instance, the example of the broken pane of glass. Failure to act in a prudent manner, such as warning about the broken pane of glass, may result in liability claims.
We're going to then move to an assault. An assault is an offer to use force in a hostile manner which causes apprehension. The person being assaulted normally must feel a degree of immediacy in the sense that the one committing the assault will execute it promptly and has the apparent capacity to do so. With assault charges, both of these definitions must be present to uphold the assault charges. Assaults may be verbal, but they may also be exhibited in other ways, such as when somebody like shakes a fist at them and gets a glare, or shakes like a deadly weapon towards them in lieu to intimidate them. The importance with all assault charges is that it is not necessary for physical injury. Fear for your personal safety is sufficient enough to establish an assault. Battery. Battery has occurred when physical contact actually takes place. In practice, a battery is a successful assault. Battery involves unwelcome and unprivileged body contact involving another person that is hostile and unlawful. School personnel are usually involved in these cases where there is evidence that they used corporal punishment. Okay, the level of degree may vary due to what type of instrument was used for the punishment, as well as the student's age, size, gender, and physical condition. Additionally, assault and battery affects teachers, administrators, and students in the school environment. The school personnel may be held liable for assault and battery in a few instances in which they observe a student being assaulted or battered by others and fail to appropriately prevent it, or even if they fail to act when it is foreseeable that one student may injure another based on threats and does nothing to prevent the injury. An example given would be if a teacher observes two students mutually engaging in a physical fight, but the teacher also knew prior that the fight was going to happen, the teacher could be held liable. All preventive measures, this is super important, that must be taken to prevent assaults and physical attacks involving students. Every person is responsible for his or her actions in cases of involving assault and battery. So earlier we talked about how the board could be responsible. This one would be on the school personnel directly in addition to the board.
So next we get into defamation and kind of what that looks like. So defamation occurs when false statements are made about another person. These statements generally are ones that tend to harm a person's good name, reputation, or subject that person to hatred, contempt, or ridicule. So kind of breaking that down, just regards to defamation, it's important to understand that in education, it's not only involving something said about a student in regards to defamation, it can also be about an employee or a fellow teacher. So it kind of applies to both parties, if you will. The book states that places such as a teacher's lounge can be a place where numerous instances of defamation can occur. This is just another reason it's always very important to be aware of what you're saying and what you're talking about, ensuring that it is not necessarily categorized as that defamation. There are certain instances where educational privilege can be a factor in deciding whether what is being said is technically classified as defamation. It's also important to understand that qualified privilege is only true. It can only be applicable if what is being said is in the best interest of that student, and that is within the true realm of what you do in the scope of an educator. So, there's kind of a difference, obviously, and you got to be informed and kind of educated with what that goes on of what you're saying about a student. Is it meant with harm, or are you trying to say something about a student to kind of reach out for support in order to assist that student? So there's definitely a fine line there. You don't want to kind of fall into that defamation side of it.
And defamation is categorized into two different categories. One is libel, and libel is oral defamation when we're speaking verbally to one another. As Quinn mentioned, oftentimes the teacher's lounge or the hallway can be a place where this happens. Libel is oral defamation of one's character, speaking poorly about a student, another teacher. And why we mentioned the teacher's lounge or hallway or that kind of piece happens is when a third party, when someone else overhears that conversation, then you can be held to that defamation of character by libel. And the other is slander. And slander is, libel is written. Slander is the oral conversation we had about someone, and taking away from their character, their good standing in the community, or sharing privileged information about that student or that teacher. And the burden of proof rests with the person who claims that injury based on those statements.
So as we move on with false imprisonment occurs when a student is detained illegally by the teacher or the principal. So just a few examples of what this would be. It'd just be detaining students against their will. So tying students to chairs if they'd not stay seated, locking children in closets, or even taping a talkative student's mouth shut. Those are all examples of false imprisonment, which is considered to be an intentional tort by the staff member. And with that, we now move on with unintentional tort. So unintentional tort is a wrong perpetrated by someone who fails to exercise that degree of care in doing what is otherwise permissible. So basically that staff member or that employee is acting negligently. So the negligence is perhaps the most prevalent source of litigation involving student injury for students. So out of all the injury to students, most of it occurs because a staff member is not doing what they're supposed to be doing with preventative care.
Standard of care. So standard of care is an important concept in cases involving liability of school personnel. Basically requires that school personnel exercise the same degree of care which a person of ordinary prudence would exercise under the same or similar conditions. Essentially, standard of care must be, essentially for students, standard of care has to be high. Most cases it will vary, but the variation mainly comes down to age, maturity, experience, and mental capacity of students. For instance, if you're going to have a standard of care for a young student, say a kindergarten student through second grade, they're going to require a higher standard of care. As you get into your older ages, such as like 10 through 12th grade in high school, the standard of care is reduced. However, that does not mean there is not a standard of care. You still have to provide a standard of care for students. The case that the book mentioned is a case in New York where two sisters were assaulted, and the school was found not to have provided the standard of care that met their needs. A teacher was informed, and they did not act upon that. They did not provide standard of care, nor did the security officers at that school provide a reasonable standard of care. So standard of care is very important in staff and personnel liability issues.
There are some defenses for negligence that school personnel can use. First one, these following defenses are used by school personnel to reduce or even eliminate the impact of liability charges against them. First one we'll talk about is contributory negligence. Oops. If the evidence reveals that persons claiming injury exhibited conduct that fell below a reasonable standard, liability charges against the school personnel may be abrogated. Basically, it's saying if it's decided that the injured party contributed to any of the injuries received, the courts may reduce or even eliminate the liability charges for the school personnel. This is probably the most common defense used in negligent cases. And there is a common law, Brandon kind of touched on it a little bit ago, common law precedent set regarding the incapacity of students to be guilty of contributory negligence. Varying on the age. A child under 7 cannot be charged with contributory negligence. There is reasonable assumption that students between the age of 7 and 14 are also incapable of contributory negligence, but it may still occur. A child older than 14 can be held liable for contributory negligence. Examples given would be a student was found guilty of contributory negligence when he was injured by a flare-up of certain chemicals that he mixed together with the prior knowledge from the teacher, given that this combination of chemicals was very dangerous. Next one would have been a high school student was found guilty of contributory negligence when he was injured while running in the dark after the lights were shut off in the school. So these students were found liable of contributory negligence. Assumption of risk. Assumption of risk is commonly used as a defense in which situations involve various types of contact-related activities, such as athletic teams, pep squads, and certain intramural activities. In theory, students assume an element of risk to participate in these activities, but the school personnel must provide the students with the knowledge and an understanding of the potential dangers involved in participating in their activity. School personnel, so even if the student has assumed the risk and is present and is participating in the activity, the school personnel can still be found negligent in providing the standard of care as mentioned earlier. Example, a student had dislocated his shoulder during an intramural football game when the school provided, so the student obviously knew that we're playing football, it's a contact sport, but then the school also did not provide protection equipment for the child, so they were also found negligent. Assumption of risk is only a valid defense when the school personnel provides the proper standard of care expected in any given situation. So, and that's, sorry. So yes, even though a student assumes an element of risk, it does not relieve the school personnel in cases where they fail to meet the reasonable standard of care based upon their age and maturity.
So continuing with another type of negligence, kind of the first part to recognize with comparative negligence is to understand how it differs from contributory negligence. In comparative, it's in a sense compares responsibility for who contributed to injury. So if you have one of the parties involved is found to have caused more of the injury than the other party involved, they're going to have a bigger share of that damage. So for example, in the book, it gave an example of one high school student was speeding in his car and another one ran a stop sign, which resulted in causing injuries for both parties. Once kind of investigating and finding out who had more responsibility, if there was a shared responsibility, obviously, the punishment will then be decided at that point. But like I said, juries will normally determine the degree of negligence, which may range from slight to ordinary to gross, depending on the circumstances. So every situation is vastly unique, and usually the law system will kind of abide by that uniqueness. And then kind of the last thing with this whole chapter on negligence and all is immunity. So immunity as a legal concept has diminished over the years in terms of its impact. Back in the day when immunity became a thing, the initial doctrine was extended to school districts due to them being a state entity and involved in state action. So some states have gotten rid of it in portions, and especially in regards to school board immunity, but others recognize the concept based on whether it is technically classified as a governmental or proprietary kind of instance. So for example, if the activity is considered proprietary, liability may be imposed based on the effects involving negligence. So proprietary is usually typically anything with like admission, something that costs money for someone involved.
So as we culminate chapter 6, one important piece to take away from this is know your district policy and procedures and be aware of those. Also too, as educational leaders, we have to recognize that our standard of care as servant leaders involves instructing, guiding others, in supervising, organizing, and providing safe building grounds and environment for our school. Part of that responsibility as an educational leader is surrounding yourself with great staff or modeling that for your staff, and building a culture of leadership, and one that holds the that high standard of education, and then we can promote that best positive learning environment for teachers and students. Thanks for being with us today.